For the afternoon. So we are going to be here today for the forensic science current concepts and issues. My name is Sydney Anderson, and I am an alumni of the forensic science program. I've actually been working on this NIJ grant for 3 years since it started. So it's been great to be here and see this conference and see all the hard work that everybody's put in. And I have the honor today to introduce Kenneth Melson. Mr. Ken Melson has served the federal government for many years prior to leaving government service from the General Counsel's Office at the U.S. Postal Service Office of Inspector General. Prior to that position, Mr. Melson served as the Senior Advisor on Forensic Science to the Office of Legal Policy at the U.S. Department of Justice, as well as Acting Director of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, United States Attorney, and Director Executive Office for U.S. Attorneys. In addition, Mr. Melson has served as co-chair of the Subcommittee on Forensic Science, Committee on Science of the National Science and Technology Council, past president of the American Academy of Forensic Sciences, and a board member of the American Society of Crime Laboratory Directors / Laboratory Accreditation Board. So it is my honor to introduce Ken Melson, and please take it away.
Actually, the one thing she forgot, which I was most proud of, for 10 years, I was a state prosecutor in Arlington, an assistant Commonwealth attorney, and that was the best place to work, is in the state system. We had so much more flexibility with respect to what we did in court, as well as our investigations and investigators. Well, I'm very happy to be here and glad that you're all able to make it. I really wanted to say that this was more like a reunion for me than a presentation because of the people that I'm seeing that I've worked with years and years ago and who are current colleagues as well. So I have to say, Joe DeZino here, Dr. DeZino, made me. He's the one who was working on my case in Eastern Virginia, the U.S. Attorney's Office, in which we had the first DNA evidence in the Eastern District of Virginia. And so he's made my whole career after getting me through that case. But what is funny about that in a recollection is that when the DNA expert got up on the stand, he started out by saying, DNA is like a phone book. You've never heard that, have you? That's the way they started out way back last century when DNA started. I also want to repeat somewhat of what Joe said at the beginning. These are all my thoughts, my opinions, not those of the Department of Justice or the NCF or my homeowners association or my wife. They're all mine. So I want to talk to you today about forensic science and our current concepts and issues. But before I get into that, I want to apologize wholeheartedly for the PowerPoint that I have here. I've read the rules on PowerPoint with respect to font size, the type of font, the number of words that can be on the slide and things like that. Well, I'll tell you, I didn't abide by any of those because I want you to have a takeaway, something that you can take away with you from this conference, among other things, that has case citations and resources and so forth. So at the very end of the PowerPoint, you will see 5 pages of resources, case citations, and other things. I didn't want to clutter my already cluttered PowerPoint with those particular items. So to start, I want to talk about connecting the dots. And you see that's a little addition to the title of this lecture, because I think what you have to do is look at forensic science in your laboratories from a holistic point of view. It's just not the examiner that you're going to call on the stand. It's just not his or her supervisor. It is the whole concept of the forensic science enterprise. And unless you know what the enterprise is and what the component parts are, you will never get a full understanding of what your analyst does and what conclusions he or she may have. So what I want to do is take all these various aspects of forensic science and connect all those dots together so you have an overview of the community, of the enterprise. Now, I can't do that in a fulsome way because this would be a 3 or 4 hour presentation. So I'm going to go over various things, and let me go on to the next slide here. Whoops, that's not it yet. And talk about things that are concepts. And each of these concepts, you may have heard of them, but not known a lot about it. The other thing I wanted to say was that there's been studies about forensic science stakeholders, lawyers, judges, prosecutors, and law enforcement people that said we all overestimate our understanding of forensic science reports and their meaning. So that applies to all of us because we're not forensic scientists. We have to rely on the scientists themselves. But that means that we've got a lot of work to do, and don't think you know it all, because none of us do. So here's an outline of what I want to speak about today. The first one is about the enterprise itself, how it's built, and why they're in such need of help, and perhaps how you can help them by understanding their problems. The needs of the forensic science enterprise, we'll talk about a recent study that shows how underfunded forensic science is. We'll talk about forensic science entities, both government and non-government. And any of you who are in political positions or the Attorney General's offices, you can help being an influencer with your state legislatures in getting more money for forensic science, because the federal government can't do it all for you. We'll talk about 3 or 4 national science reports, which are being used over and over again by the defense, particularly in firearms cases. We're going to talk about standards development. That is one of the ways in which we clarify error rates, as all of these things I'm going to talk about today really affect error rates. And then some more recent concepts and developments that you should be aware of. So let's start with the forensic science enterprise and how big it is. Now, this is a BJS report from 2014. There is another one coming out very soon. It's being printed and produced. Unfortunately, I did not have access to those numbers, but these numbers help you understand what the community is like. So, you know, there may be a couple bad apples in the forensic science community. You all probably can name 5 or 6 of them, but you have to realize that there are 409 crime laboratories in the United States back in 2014, and that doesn't count a lot of the police 1 or 2 person forensic scientists who do latent prints or maybe firearms identification. Even the major organization in the United States that has members from every crime lab in the country, they don't know how many. They couldn't figure out how many there actually are. So we have a huge number, and there's over 14,300 employees in the forensic science community. So we have a big process to do or to look at. What you need to do is know what your laboratories are about, what their problems are, and the qualifications of them and their analysts. Someone mentioned earlier a backlog in Montana. Well, the backlog is everywhere. Back in 2014, there were a backlog of 570,000 cases. And now we have a huge backlog of rape kits that have been in custody of the police departments that have never been analyzed or cataloged. And this is back then the number of the types of examinations that were requested of laboratories. And you'll see that drugs and guns are pretty important back then, and they still are. Now, DNA was 19%. I'll bet you today that it's much, much more. Unfortunately, some laboratories are closing units in their forensic laboratory because they either can't afford to have analysts in that particular discipline, or they cannot have enough employees or people to apply to do that discipline. So there's a manpower shortage as well. We also wanted to hit medical examiners and coroners because that's part of this conference. So there was another BJS, and by the way, BJS is the Bureau of Justice Statistics in the Office of Justice Programs in the Department of Justice in the US government, just down the street. All right, so they do these studies every 5 years. And they said in 2018 that there were 2,040 medical examiner coroner offices in the US with 890 forensic pathologists, those who can do the autopsies. And you see the number of deaths that were accepted by the ME. Now, that doesn't mean they do an autopsy in every one, but they have a lot of deaths every year, and even more with the fentanyl problems. And then we had the pandemic and things like that. So they are very under-resourced. I thought this was an interesting slide because it talks about the different combinations of medical examiners and coroners in the US. And so you need to know what the situation is in your state. We heard what Montana was. It was horrible. But so some states have a medical examiner central system like Virginia does. Some have a combination of medical examiners and coroners are elected officials. They may not have any forensic or medical expertise whatsoever. And then you have some that have both, and it is just a real system that needs to be looked at and organized. So one of the things we need to look at with respect to both medical examiners' offices, coroners' offices, and laboratories are some of the things that they do in order to help the courts understand that their work product is reliable, reproducible, and valid. One is accreditation. Laboratory accreditation looks to make sure that you have a good management system and a good technical operation. They don't tell the DNA examiner how much of a sample to put in what tube and stuff like that, but they make sure that you have a management system, a quality manager, and that they have processes in place for each of the disciplines that they do. It's very important that laboratories are accredited. Now, the good news is that back in 2014, 99% of the state laboratories were accredited. That's been a huge lift since I was on the accreditation board, again in the last century, when it was called ASCLD Lab. So there are many more that still need to be accredited, and there's federal money to become accredited. So these smaller laboratories, local laboratories, and so forth can get grants. And I don't mean to step on any toes here, but you can get grants to become accredited. So that's important. The two leading accreditation organizations are ANAB, the ANSI National Accreditation Board. And you need to know these acronyms and the accreditation bodies, because when your witness is on the stand and he says, oh, we're accredited by ANAB, you got to know what that is. And you've got to explain it to the jury. And even more important, you have to make sure when he tells you what ANAB is, that he actually says the right name. All right, that was one of the things in some of my trial practice cases or court classes where the examiner couldn't say what ASCLD Lab meant, couldn't say what ANAB meant, and you know what signal that sends to the jury when they do that. Now, this is a term, and I know it's after lunch and it's nap time, but the term ISO and what the accreditation boards use as standards. ISO is a international organization that provides standards for almost everything. and they provide accreditation standards for almost every company there is that produces something. So it means ISO stands for International Organization for Standardization, even though the acronym is ISO, because the translation of that, because it's centered in Europe, is the International Organization for Standardization. And IEC is the other partner with them. And there are two ISO standards that you really need to know about. One is for laboratories, and you can have your office buy these online if you need to, and for forensic science units. The other accreditation program is sponsored by the FBI, and that's the quality assurance program for DNA. If you're in a laboratory that does DNA and wants to use CODIS or ENDIS, they have to pass this accreditation by the FBI QAS. Now, they don't actually do it. They outsource it to ANAB and A2LA, who do the actual accreditation process. So in a single lab, you might have at least two accreditations that you need to be aware of. The MEC offices are a little different category. Their problem is they have a lot of medical examiners' offices and coroner offices that are not accredited yet. A lot of the coroners, I don't think, have the money to be accredited or even know about accreditation or don't have a staff for which they can become accredited. But you see here that there are only 17% in 2018 that were accredited. The two accrediting bodies you need to know about for medical examiners, one is NAME. See, there's lots of acronyms. National Association of Medical Examiners. And of August 22, they had 89 fully accredited ME offices and a number of provisional offices. There's also an accreditation body for coroners, and you're going to have to realize that they are separate entities and have separate rules, and that is IACME, which is the International Association of Medical Examiners. They have 36 offices accredited. ANAB also does some accreditation, but you can see we're well short of accreditation in medical examiners' offices. I think that toxicology is an integral part of the medical examiner coroner offices, because how many times have we seen it on TV? Oh, we don't have a autopsy report yet because we're waiting for the toxicology. Well, almost every case you want the toxicology. So we have to make sure that they're accredited as well. So when you see that tox report along with the autopsy, go back and see if they're accredited. The two boards there are ABFT, the American Board of Forensic Toxicology, and ANAB. Now, that takes care of the lab. I mean, that's great, but what about the individual? She is the one that's actually testifying for you, and she is there on the stand to prove to the court in the voir dire that she's qualified. One of those things is individual certification. This is a certification by an outside external party that gives an exam on their particular capabilities and knowledge and experience with respect to their discipline. It's a way to make sure that they have minimal qualifications to do what they're supposed to be doing. And certification is really catching on now. 72% of the crime labs had at least one externally certified individual. It's much higher now, I know, because I'm involved in those things. The medical examiners aren't certified in forensic science. They're certified by either College of the CAP, the College of Pathology, whatever it is, I forget right now, or the American Board of Pathology. And so they are important ones, but they're not really focused, as I think they should be, on the certification of those medical examiners, because they're part of the medical legal part of the forensic science field. Now, there are lots of organizations, so if you have an expert on the stand, you will be able to look at the certification processes that they have if they are certified. This is only a small list. The rest of the list is in the appendix under references, which gives you an idea of almost everybody can be certified, and they should be certified. Proficiency tests are another issue. And this again goes to quality assurance and whether your examiner and your laboratory are capable of giving valid, reliable, reproducible evidence. And these proficiency tests are given to the laboratories or to individuals in the laboratories that test them on their proficiency in doing an exam. And as you see at the bottom, there are a number of types of proficiency exams that can be given. They can be blind, where neither the lab nor the individual or the individuals who are taking the exam know that it's a proficiency test. There are those that are that's double blind. The blind is when the examiner doesn't know. Double blind is when the examiner and the laboratory don't know. There are exterior ones, interior proficiency tests, and some that are open and declared saying, okay, we're going to do a proficiency test. Everybody knows. But you need to know their rate, because if they fail a proficiency test, then they get off the bench and they go through rehab before they get back. And I don't mean rehab because of drugs, but they have to show again that they're competent to take a test. And remember that proficiency tests are different than competency tests. Competency tests are those tests given by the laboratory before an employee is allowed to actually do bench work. Then you have the proficiency tests to continue to test their ability. Now, these courts don't like proficiency tests. I mean, I've got a couple of cases that are cited in the reference where they criticize proficiency tests because they only deal with a minimal proficiency, not one that's necessarily like the normal casework that comes in. Code of ethics. When I was with ASCLD Lab, I was the primary author of a code of ethics for crime laboratories, and I think it was the first national one. And of course, a lot were adopted because many were becoming accredited. Well, that went to the Subcommittee on Forensic Science, which adopted a variation of that, and then went to the NCFS and the Department of Justice, who now have a national code of responsibility for forensic scientists. The needs assessment that I was talking about, just very shortly here, and that is that this is a study conducted by NIJ, I believe, and they have determined that the forensic laboratories need about $640 million more before they can catch up and equalize the intake and the examiners that are there. And with respect to forensic pathologists, it's really worse with respect to the individual forensic pathologists and the streamlining of new pathologists coming in to the workforce. And a number of us are working on trying to streamline and accelerate that workforce issue. But they say they need 1,000 to 1,200 more forensic pathologists in the country. Let's look at a couple of the entities that we have here that help the forensic science community. The first is the National Institute of Standards and Technology. Robert Thompson over here is from NIST, and he'll be talking about firearms. They do a lot of research and implementation of ways in which to analyze evidence. DOJ's NIJ, National Institute of Justice, does research too and has grants for research to be done in the field. Bureau of Justice Assistance does grants under the Coverdale program. And the interesting one here is there is a provision in the law that allows state prosecutors that have cold case units to apply for a grant to work these cold cases. So that may be something you want to look into. The National Science Foundation, we've been trying to drag them more into the forensic science field as into applied forensic science. They don't want to come, and we're still working on that. Some of the national government forensic science entities, one was the subcommittee that I mentioned to you. This was out of the White House. Mark Stollerow from NIST and I were the chairs of that committee. And it wrote a report. We had 200 subject matter experts come in and talk to us and work on working groups. But the interesting thing there was within the federal government, guess how many agencies actually did some forensic science work? Well, the answer is right up there, 23. We're thinking ATF, FBI, DEA, Department of Homeland Security. That's only 4 of the 23 that were there. The National Commission of Forensic Science was an offshoot of the Subcommittee on Forensic Science. It was a recommendation that the Department of Justice on the one hand and the NIST, who are the scientists on the other hand, collaborate on forensic science issues. They wrote 42 papers. You can see what some of the papers were on. Why do I mention that? Because the courts from time to time are citing these reports on various issues relating to laboratories and the individual analysts. Now, there are state forensic science commissions out there, and I'll go through this pretty quickly. There was a report in 2016 about the types of, about forensic science state commissions and other variations of a commission. In 2022, they updated that, and now 21 states from 10 back in 2016, 21 states now have state commissions. And so here's a map of the state commissions. Might be hard to see what each color pertains to, but you'll have it on your take-home PowerPoint. So of those people who are in attendance here as students, you can see the different states and the different types of committee of forensic science commissions. Marna McClanahan, who is working on these issues, will be here this week. She's coming from Arizona, so she probably had travel problems too. But talk to her about your commission and what type of commission has been successful in another part of the country. There are also non-government forensic science organizations that can help you in preparing your case. Most of the examiners are going to be a member of a forensic science organization. And so you need to talk to them about what that organization is, what kind of training do they give? You know, have you ever been subject to a disciplinary action within that organization? So all that is very important to know. One of the organizations that I'll highlight is the American Academy of Forensic Scientists. And as was said in my introduction, I was the past president of that, but I'm here to say that's a good organization for you to apply to because they have a jurisprudence section specifically for lawyers, and they invite the lawyers in. There are prosecutors, judges, defense attorneys, innocent project lawyers there. It's a great place to learn and get connections to forensic scientists all over the country. So I commend that to you. And the list of other organizations, where was I, are in the appendix. Let's talk about a couple national tests that you need to know about. One is the NRC ballistic imaging report that's used in your firearms cases, an awful lot. They were trying to determine whether it was feasible to have a national ballistics database. They concluded that it wasn't, even though they remarked in their report that the validity of the fundamental assumptions of uniqueness and reproducibility of firearms-related tool marks had not been fully demonstrated. And that's what they focus on. In Washington, D.C., the prosecutor, the prosecutor in charge of their forensic science lawyers had the chair of this committee write an affidavit saying that did not mean that it was not admissible in court cases and so forth. So the good thing is that report has been pretty much kicked to the side. Here I've violated my own rule and had 2 court cases cited there, but they have both said that they're outdated. Both that and the National Academy of Sciences report are outdated by over a decade, because so much has happened in the firearms field, as well as in all the recommendations, most of the recommendations that the National Academy of Sciences reported on. So the National Academy of Sciences issued the report in 2009. It was astounding, such a backlash you wouldn't believe. I was actually at the American Academy annual meeting, when that came out. Everybody was very much opposed to it, because a lot of it was talking about various disciplines and their critique of the various disciplines. But now, as I said, some courts are recognizing that those critiques are outdated, that we've made a lot of progress. But the important thing from that report really wasn't the critique of the disciplines, but it was the recommendations they made to the forensic science community as ways to become more reliable, more credible, and so forth. The first thing they suggested that I don't have on here, because it was dead on arrival, was a creation of a federal government agency in charge of forensic science. Well, you don't create new agencies out of whole cloth anymore. So that was never acted on, never had a chance of doing. But they talked about things like terminology and model laboratory reports. And there are actions on both of that, both with respect to the organization of scientific area committees that I'll talk about in a second, as well as the NCFS, the National Commission on Forensic Science. And these various organizations are coming together, working on trying as much as they can, despite the differences between different disciplines, to come to common terminology. So when they say inclusive in one, it means the same thing as another discipline. The model laboratory reports have been worked on. NIST had 2 working groups at least, one on question documents and one on latent prints, which you ought to read if you have scientists in either of those testifying, that talked a lot about what has to be in a report, what should be in a report. And the same thing with the DOJ NCFS. So they've done that. There's been plenty of research done and sponsored by NIJ and by NIST on ways to increase the accuracy, reliability, and validity of forensic science. The 4th recommendation here was to take laboratories out of the police department and into a non-law enforcement agency. Virginia has done that. When the laboratory director is going to be here when she's here, ask her how that's working, because it's working pretty well. But you'll notice too, when you look back at some of the bad apples in the process, some of them are from laboratories that are outside of law enforcement. So that's not the sine qua non of reliability and validity for their work products. All right, I had stars. Look at that. All right, research regarding human factors. I'll talk about that a little bit later, but human factors are the biases. What kind of bias? A cognitive bias, a expectation bias. How much of non-domain information are you receiving that might affect your analysis or results of your examination? And we've come a long way now. Almost every case I read where they're discussing under Daubert whether something is reliable, they talk about bias and what the laboratory is doing to eliminate those issues that create a bias in the examiner. Developing tools for advancing measurement. You talk about protocols, that's what standards are, and there are other things that they're doing there. Accreditation, certification, we've talked about that. We've come a long way in accreditation. We're moving forward on certification. And the quality assurance programs that labs have, well, along with accreditation comes a quality assurance program. And they have to have, or they need to have an individual who's partly responsible in their job description for quality assurance. So you have to have a quality manager, someone that makes sure that, you know, the things that need to be updated or changed or validated before using are all done. See, I forgot my stars again. All right, so one was to establish a code of ethics. Well, the department has done that. Pursue graduate studies in multidisciplinary fields. That's what a lot of these conferences do. They have studies, not studies, but they have educational conferences. I don't know what else they've done with respect to graduate studies. There are master's programs. In fact, Robert Thompson here is a graduate of mine from George Washington University, Department of Forensic Science. I made his career. Joe made mine, I made his. So support law school. How many of you are in states that have a law school that has a course on forensic science? Anybody here? DC has one. Oh, Virginia now has George Mason here. There aren't many of them. There aren't many at all. So the second to last one, this one, the goal of replacing and eliminating existing coroner systems. Now that was another one that was dead on arrival. You know, coroners are elected. They're part of the state system. And I think it would be very hard to come in from the federal government and tell these state elected officials that they no longer have a job. What they need to do is improve the offices that they have. They are doing that. They have forensic pathologists that are doing the pathology work, even though the coroner may be a dog catcher, as the old saying goes. And I don't mean to demean them because they play an important role. APHIS is another issue. If you're in a jurisdiction that has one type of instrument for searching for prints, when you have an unknown crime scene print, you may not know it, but you're not searching the US. You may only be searching your jurisdiction. In DC and Maryland, because you know the criminals go from state to state, they have a compact where if we have a latent print and we want searched, we can search it in our database. We then have to move over to another terminal and search it in DC, and maybe a third terminal to search it in Maryland. So it's a real issue. NIST is working on this. It has done a lot of studies on how to make these different systems interoperable. So when you put something in to what you think is the national APHIS to search for fingerprints, you actually do search all the databases. All right, let's look at the PCAST report. That's the most recent report. Again, it was very widely criticized by forensic science agencies and government agencies. Those responses to the PCAST are in my references. This was another committee that came out of the same section of the White House, the executive office of the White House, that our subcommittee on forensic science came. One of the criticisms was that nobody on the PCAST was a forensic scientist. They had people who were advisors to them, but they were all judges. So they interviewed people and had presentations on forensic science, but that's not like being a forensic scientist that knows the inner workings of these studies and the protocols and processes of analyzing evidence. It was limited to impression evidence or feature comparison evidence, such as DNA, where you're comparing the features there. They said there were two things that you had to have in order to be able to say your discipline and process is valid and reliable. And that is, you have to have foundational validity. All right, foundational validity, which means you have to prove it's repeatable, reproducible, and accurate. And then the second stage is validity as applied. In other words, once you show that it's a valid scientific process, did the examiner actually do it correctly on the piece of evidence that you have that's going into court? And that's all part of Rule 702 now, which was modified in 2011 after the Daubert decision. One thing they do say that is good, because this has been cited by courts too, with respect to studies, primarily on firearms, because that's the case in which it's most likely to be used. They had some studies that showed 2.2% error rate and so forth. Well, PCAST says, it's okay if the error rate is 5%, but more likely and better, less than 5%. To be considered to be reliable. That's the percentage of false positive reports. So they say that you have to have an empirical study, because all these feature comparisons are, quote, subjective methods. And for subjective methods, you have to have empirical research, and that means black box studies. Now, they came up with this whole black box, as I understand it, study bit, because they looked at hundreds and hundreds of studies in the various disciplines that they're looking at, but they didn't like any of them because they weren't structured as PCAST would want them to be structured. So they discarded an awful lot of those because they didn't have one or more PCAST black box structured designed study. That had a huge blowback as well. And so in the end of the study, they said they listed these items that they looked at, and FV is foundationally valid, and not FV means they failed. And you can see the disciplines that they said failed, and firearms, well, you almost made it. Come on, do a little bit more, and then we'll say you're good to go. So those are the results of it. And that's why you have to be familiar with PCAST, because I'll tell you, and most of the cases now, which involve these disciplines, you're going to have a PCAST challenge. And we're going to talk about that, I think it's tomorrow, on the Daubert PCAST presentation. Now, National Center on Forensics here at George Mason with Joe has this database, which was already mentioned. You can go on and look at that database for cases involving PCAST since PCAST, but it ended in June of 2022. I went in during the preparation of this and found what I think is every case that mentioned PCAST since June of 2022 up till yesterday. So those cases are all listed in the reference to look at those, because the later ones are even getting better. I mean, it's not new anymore. The PCAST isn't new anymore. And each of these disciplines have done so much more that, as one court said, it's becoming outdated as well because of the black box studies that they're doing. And that's what's been great about the forensic community, is that when they had the National Academy of Sciences report with all those recommendations, they started working on them. And what you ought to do is look at some of these things that they have done. John Butler from NIST did a wonderful presentation on all the advances since the NAS report to a presentation at the AAAS about what has come up. He's got that PowerPoint. Get it and look at it, because that will get you through the NAS report. PCAST is a little different. But still, we're making progress in that because there are more black box studies. I'm sure Robert will tell you about more of those in firearms, which completely decimates PCAST. So there are other things that were private, not government funded institutions that worked on forensic science, and they were called SWIGs, the Scientific Working Groups. They were pretty much all volunteer. They had no organization that looked at all the SWIGs to make sure that they're organized, that they're funded, that their process of developing standards was appropriate, and so forth. So when we started moving from the subcommittee in forensic science into the NCFS with NIST, NIST started what's called the Organization of Scientific Area Committees, otherwise known as OSAC. So one of the things you're going to have to do when you have your witness on next is go into what they call their registry. And their registry contains two different types of standards that are being developed. One is the published standards, which have gone through a standards development organization. I'll explain that in a second. And two are the standards that OSAC has prepared as proposed standards, but not yet have they gone through an SDO process. So as of July 5, 2023, there are 106 published standards and 48 proposed standards. That means one of those might affect your laboratory or your expert. Now, these aren't mandatory, so your laboratory may not have adopted them, but you know what the defense is going to ask. Are you aware of these standards? Yes, I am. Did your laboratory adopt these national standards that were proposed by NIST? No, we didn't. Why not? I don't know. So you got to know, in order to prepare your expert, what standards might apply to the laboratory or to him. Now, here is a picture of OSAC. I mean, it's a tremendous organization, and they're all volunteers, except for a couple paid directors. But you see that there are 7 scientific area committees, and you can see them. These are the big umbrella committees, and under them, they have 22 discipline-specific committees that look at a specific discipline and providing standards for that discipline. And there are hundreds of forensic scientists on this, as well as judges and statisticians. So it's a broad group of people that are developing these standards for the forensic science community. Now, I mentioned the Standards Development Organization, and they are organizations that take the standards from OSAC and apply international and governmental standard operating procedures in order to develop this into an American standard, which then becomes an official standard, not a mandatory one, but an official standard around within the United States. And these are the 4 entities that are standard development organizations that look at standards developed by OSAC. And you can see that National Fire Protection Association is one of them. The American Academy of Forensic Sciences has one. ASTM, I'm sure you've all heard of that in one way or another when you look at your package of something you bought. Its E30 committee does the same thing. All right, so here are some recent concepts and developments that we should look at that are new, that I can't explain everything about them to you because I'm a lawyer, and particularly with respect to the statistics. That's why I went to law school, so I don't have to learn about statistics, and now you've got to try and learn about statistics. So now, source attribution, there are a number of things that many say, including the NCFS and the Department of Justice, say you can't say, such as to the exclusion of all others. You can't be that specific. You can't say 100% certainty. You can say other things that you will see in the documents that I'll talk about in just a minute. One of those things is the confidence in the conclusion. The department, the NCFS, the DOJ group, and adopted by the Department of Justice, is that you can no longer say to a reasonable degree of scientific certainty. How many of you use that in court when you have an expert? One. Oh, come on. I know there are more because many, there you go, because many states require, or at least are accustomed to having the experts say to a reasonable degree of scientific certainty. But as Dalbert said, and as others say, there is no certainty in science. So it's a very confusing statement that no one really knows what it means. People are confused by it, and it probably gives validity to otherwise fallible forensic science. That's not 100% certain. So wouldn't it be contradictory to say, oh, I'm 100% certain that this matched that, but it's only to a reasonable degree of certainty? I mean, it just caused problems. So now at least federal experts can no longer use this term, whether they're in federal court or state court unless the court insists that they use that particular term. We talked a little bit earlier about cognitive bias. That is something that has come up in the last 4 or 5 years. Itiel Dror, who is a professor over in England, has really capitalized on that. And now everybody is talking about cognitive bias in the laboratories and in the with respect to the analysts themselves. So I wanted to ask today whether or not in the case that was presented to us, how much information did the medical examiner have that was not domain relevant? In other words, did they know the race of the individual? Did they know the type of publicity the case is getting? Did he know whether he was sexually assaulted or not? Those things that will create a bias in the mind because it's so horrible that they don't need to know necessarily, except the sexual assault aspect, for purposes of their examination. And so I have a number of things in the references that talks. There's a great video that the National Clearinghouse on Science and Technology put on that is Itiel Dror talking for an hour. It had a humongous number of people watching that, and it was very good. It takes you from A to Z on that. And then there are statistics, and I'm not going to say anything about any of these because I don't know anything about those. And even though I've been to a number of presentations on stats, I'm lost with it. And I think a lot of lawyers are lost with it. And that's where you have to be careful that you don't have overconfidence in your own opinion of whether you understand statistics. One of the things that is spoken about a lot is whether in these database, in these black box studies, when they measure the correct answer, the inconclusive answer, or the wrong answer, or actually the inclusive, inconclusive, and exclusion answers, whether you count the inconclusive answers as a right answer or a wrong answer, because that tremendously changes the stats in it. And maybe Robert can explain that much better than I just failed to do. But also I have in the references a number of videos on stats, some from CSAFE, which is the NIST Center for Statistics and Application in Forensic Science. They've got videos on it. You've got to learn these and really sit down with your expert, because if you get a defense attorney who more than likely doesn't know any more than you know about it, gets up there and starts making misrepresentations unknowingly, then you're going to have to correct those on redirect. And finally, forensic genetic genealogy. I mean, you've heard the Giglo, is that the name of the beach up in New York, where they found another body nearby with the head a couple miles away. They found out who she was. In Idaho, that particular case, they were able to track down the defendant. It's an emerging technology, which now is very important. It's got to be developed more, validated more, and we've got to overcome the Innocence Project's complaint that it's an invasion of privacy, all the privacy rights that are surrounding it. And we have a presentation on forensic genetic genealogy, but that's really been helpful in a lot of cases, as you know, by reading. Finally, are the ULTRs. See, everything has an acronym, even though it doesn't roll off your lips very easily. ULTRs. So ULTRs are the Uniform Language for Testimony and Reports, developed by my old office, the Office of Legal Policy at the Department of Justice. And what they did was they determined, or they came up with an explanation for different disciplines as to what they can say and what they can't say. So the first thing is what I said earlier, was that no federal expert, unless directed by a state court judge, can use the reasonable scientific certainty statement with respect to their opinion. No one can say zero error rate No one, and you can no longer, and this happened a lot in the past, have the expert say, well, I've examined 600 cases on ballistics, and therefore I'm an expert. You can't bolster the witness on the grounds that they just did a lot of examinations. Why? Because there's no ground truth. We don't know whether those exams were right or wrong. So how can we say you're an expert based on something we don't know what the ground truth is? So there are things like that in these alters that will affect you if you have a federal forensic science expert on the stand. And they may also be used to cross-examine your state expert if they're saying something different than the alters suggest you should or should not say. So you've got to be prepared by looking at that. All right, so here are the references, and I've divided them up by different of the different categories we talked about: accreditation, certification, and so forth. And down here are these are the state cases since June of 22 involving PCAST in particular, and here are the federal cases which do the same thing. And so hopefully that will reduce your research a little bit if you have a case that involves PCAST. So I think, according to this clock, I have 4 minutes left, so I left time for you to ask questions. Yes, ma'am.
What questions are effective in relating to what that uniform language should look like?
You mean as a defense or as a prosecutor?
As a prosecutor.
Well, I don't know that you would have to ask him any questions, because he or she is going to give the right response because they're required to, and their testimony is monitored by their agencies. So they'll just give you a response, or they won't say to a reasonable degree of scientific certainty. They won't say 0 error rate. The question is more if you have a state officer there that doesn't follow those guidelines, and the defense questions him or her on why they aren't following that. Are you aware? The answer to that is not what questions should you ask them, but you should have found out that before you put them on the stand, so that you bring out anything like that, perhaps in direct examination, instead of waiting for redirect in order to clean up the mess that the defense has created. Does that make sense?
Yeah.
All right. I'm surprised. Yes.
Okay, sir. Large percentage that every doctor in my office uses not scientific certainty, but a reasonable degree of medical certainty.
Pertains, same thing.
Yeah, so what should we drive them toward in order to change that narrative?
What they have to do, what I think they have to do under that concept, is to come up with ways to show their confidence in their result. Like saying, I'm very confident in my result that X, Y, or Z. Or I'm depending on what it is, because as you know, like in question documents, you have like a 9-point scale or something. So they should talk about their confidence in it, which people understand. If I say I'm highly confident, you can expect that he really believes it. But if you say I'm confident, or I'm pretty confident, or things like that, that doesn't imply an absolute certainty, like the statement is like reasonable scientific certainty does, then I think that's the way to go. Anything else? We have 1 minute. Yes, sir.
Have there been any reports or any of the studies done recently regarding the use of, in a case, or the introduction of doing it in court with NIBIN directly?
I don't know that. I don't think there's anything in which NIBIN is introduced in court, because NIBIN is an investigatory tool. It's like APIS, or it's like CODIS. It spits out some good subjects for you to examine. Have you had a case where they tried to put NIBIN in?
There was brief discussion, but they never did.
Yeah.
We used it in the investigation side.
Absolutely.
but there was talk of whether it should go to that extent, and that was definitely not breached.
Yeah, so you have to disclose it as part of discovery.
Right.
But I don't think that it's ever admissible. I don't think, unless Robert has heard, and he knows everything about firearms in Niven. And was there another? Yes, sir.
Are you aware of any discrepancies or contradictions between different jurisdictions in the country with respect to the admissibility of certain types of forensic evidence? Like the state of Washington allows you to go this far with this piece of evidence, but the state of Maine doesn't.
Yeah, you read any series of cases from different jurisdictions on particular disciplines, some more frequently than others, but the courts do disagree. And one thing they disagree on is whether, for instance, in firearms examination, I use that because that's most of them, limiting the type of testimony you can give as to the results of your analysis. Some do, some don't. Some will throw out evidence. And one of the reasons, I was on the NIST question document working group, and I looked at all the federal cases in which question documents evidence or examinations had been thrown out. And do you know why they were thrown out? Because the examiner on the stand wasn't prepared. In each one of those cases, they said, well, I'm not familiar with that study. Or, yes, I read the study, but I don't remember what it said. And each one of those cases that were thrown out because of the lack of preparation by the examiner. That's why you have to prepare your witness. Always have your pretrial conference with him or her in person and go through it. I think my time is up because I see a glare from Joe. So thank you very much.